The business laws, it's basically all the various laws which are with regards to various transactions and commerce. Okay, so the various laws of business. So we have already learned about the Indian Contract Act, and besides that, we learned also under Unit 1, we've learned about the various different kinds of special contracts also. So now we're moving on, and in your second unit, we're dealing with the Sale of Goods Act of 1930. So from the term itself, it's with relation to the sale of different goods and services. Okay, so the Sale of Goods Act under Unit 2, it will consist of these various topics. We're going to learn about the formation of the contract of sales, and then goods and their classification, as well as the pricing of different goods. And we're going to learn about the terms, conditions, and warranties, and then about the transfer of property in goods. And we're going to learn about a term known as Doctrine of Caveat Emptor. And then we're going to also learn about the performance of the contract of sale and sale by auction, and about the unpaid seller and his rights, carriage by land, and also about the hire purchase agreement. Okay, so these are the various terms, various aspects which are there in your Sale of Goods Act. So when we're talking about the Sale of Goods Act, a contract, we're going to be dealing mostly with the contract of sales. Now, originally, the transactions which were relating to the sale and purchase of goods, they were regulated under Chapter 7, Sections 76 to Section 128 of the Indian Contract Act of 1872, which was broadly based upon the English common law. So basically, all of the transactions or all of the rules which are pertaining to the sales and purchases of goods was regulated by the Indian Contract Act 1872 originally. Okay, so however, as time passed, a need was felt to overhaul the law, especially due to rapid growth of mercantile transactions and various progressive English judgments being passed to meet the needs of the community. And as a result of that, the provisions of Chapter 7 were repealed and they were amended suitably, keeping in mind the English Sales of Goods 1893. And after that, various decisions were made. After various decisions were made, a separate act known as the Sale of Goods Act came into force on 1st of July 1930. So basically, your sale of goods, they were all the transactions with regards to sale and purchase of goods were under the Indian Contract Act of 1872. And however, as time passed, the sections 76 to 123 of the Act were repealed. And because of that, they created a new act which was termed as the Sale of Goods Act on the 1st of July 1930. So a contract for sale of goods has various peculiarity features. Okay, they have various peculiar features such as the transfer of ownership of the goods, delivery of goods, rights and duties of the buyer and seller, and then remedies for breach of a contract. And so these various peculiarities, right, all of these are the main subject matter for the provisions of the Sale of Goods Act. The main reason why they felt the need for a Sale of Goods Act was, besides all of these changes, because there are so many various things that are specifically only for sale of goods, which take into consideration the Indian Contract Act, but also quite different. So as a result of that, they also became special contracts, and now we have a Sale of Goods Act. So the Sale of Goods Act, it basically governs the contracts which are relating to the sale of goods, right from the name itself. It's a contract for the sale of goods, and it extends to the whole of India except the state of Jammu and Kashmir, and it does not affect the rights, interests, obligations and titles acquired before the commencement of the Act. If anybody has bought or sold anything before the Sale of Goods Act of 1930, it does not affect those transactions that have already been in effect. So the Act deals with sale, but not with the mortgage or with the pledge of goods. Okay, it only deals with the sale and not with anything else. So let's look into the definition of the sale under the Sale of Goods Act. So Section 4 of the Sales of Goods Act 1930, it defines a sale of goods as a contract of sale whereby the seller transfers or agrees to transfer the property and goods to the buyer for a price. Now, the term contract of sale includes both a sale as well as an agreement to sell. That means when you have already sold, when you have gotten the money, and when you've promised to sell sometime in the future. So in simplest terms, a contract of sale of goods is a contract whereby the seller transfers or with the ownership of goods to the buyer, or he agrees to transfer it for a certain price. So always remember, there are certain things which are elements. Okay, so based upon this definition, we'll be able to learn about the various elements which are regarded, or the characteristics which are required for sale. Okay, so remember this definition as per section 4 of the Sales of Goods Act 1930 for sale. Now, a contract of sale, remember, is made by an offer to buy or sell goods for a price, and once the offer has been accepted by the other party, then it's said to be a contract. And the contract may be oral, or it may be in writing, and it may be absolute or conditional. Basically, it follows the Indian Contract Act itself. So what are the various formalities with regards to a contract of sale? Now, section 5 of the Act, it specifically provides for the following 3 steps or formalities with regards for a contract of sale. So firstly, just like in case of the Indian Contract Act, there should be offer and there should be an acceptance. Somebody should offer to sell and somebody should accept the sale or the offer for sale, and then it will be termed as a Sale of Goods Act. So first point, as you've seen, offer and acceptance. A contract of sale is made by an offer to buy or sell the goods for a price and the acceptance of such offer. So when we're talking about contract of sale, it's not just an offer to sell, it could also be an offer to buy a product. Okay, and the second point is delivery and payment. Now, it is not extremely necessary that the payment for the goods to the seller and delivery of the goods to the buyer must be simultaneous. It's not like when you go to a shop and then you ask for a pencil, they give you the pencil and you pay 5 to 10 rupees for the pencil. It's not like that. Okay, when we're talking about Sale of Goods Act, it could be even payment in installments, it could be even credit sales and payment at a future date. It depends all upon the contract itself. It's not something that has to happen then and there, simultaneous purchase and receipt of money. All right, and finally, the third formality is expressed or implied. So the contract with regards to the sale of goods, it has to be in writing. It can be either oral or it could even be implied. It can be partly oral and it can even be partly written. All right. So these are the main formalities with regards to contract of sale. Now, what are the essential characteristics for sale of goods? So when we're talking about sale of goods, there are 5 important features of the sale of goods. So first feature, as we can see, is it requires 2 parties. So just like in case of a contract also, we have 2 parties, right? In case of the Indian Contract Act, remember? Similarly, in case of sale of goods also, we require 2 parties, the buyer and the seller. Now, the sale, it has to be bilateral because the goods have to pass from one person to another. As a result, there should always be 2 parties. One will be a buyer, the person who agrees to buy the goods from and a seller, a person who agrees to sell or who is going to sell the goods. Now, the buyer and the seller must be different persons. The buyer himself cannot sell the goods to himself, right? The seller cannot sell the goods, cannot be the buyer itself. So a part owner can sell to another part owner. That meaning, if one good is divided into 2 portions, okay, let's say you have an entire building, it has 2 stories. First story belongs to a different person, second story is belonging to a different person. So if one of these owners, let's say the person on the first floor decides to sell it to the person on the ground floor, right? So they are part owners of the one full building, they can sell it to each other in that situation. Or for example, a partner also, he can sell his firm, that is, he can sell his portion to the firm to another partner. Okay, in that situation also, there are 2 parties involved, so that is also allowed. However, if joint owners distribute properties among themselves as per mutual agreements, then it is not a sale. Okay, for example, if you're sharing a pizza amongst your friends without taking money for it, then that is not considered as a sale. A person cannot be the seller of his own goods as well as the buyer for them also. Remember that, keep that in mind. There will always needed to be 2 parties. And the second essential element is subject matter has to be goods. That is a subject matter, that is the reason why you're entering a contract, it should be a goods. And the term goods has been defined in section 2, subsection 7 of the Sales of Goods Act as goods means every kind of movable property other than actionable claims and money, and includes stock and shares, growing crops, grass, and things attached to or forming part of the land which are agreed to be severed before sale or under the contract of sale. So when we're talking about this particular point, it refers to all things that can be considered as goods. So basically, every movable property other than money and other actionable claims. So therefore includes stock, right? Your equity shares, preference shares, debentures, all of these stocks, shares, and then growing crops. So it could, if you're a farmer, then all of your crops, then the grass, and even all of these things which are attached to or which form a part of the land, like your trees, rocks, all of those which can be severed before or under the contract of sale. All of these are referred to as goods. Therefore, your things like goodwill, copyright, trademark, patents, water, gas, electricity, all of these are considered as goods. And remember, money is not clubbed as goods. Okay, money is basically the consideration you're paying in return for the goods, so it cannot be clubbed as goods. And the third element we can see there, transfer of ownership of goods. Now, there must be transfer of ownership or an agreement to transfer the ownership of goods from the seller to the buyer. Okay, not the transfer of mere possession or limited interest as in the case of pledge. Not just giving them property for a certain period of time, but rather for the entire period of time. Okay, like in case of lease, hire purchase agreements where you're only giving them property for a certain period of time. All right. So if the goods remain in possession of the seller after the sale transaction is over, then the possession is with seller, but the ownership is with the buyer. Like for example, if you're buying a car, in certain situations, the car may not be given to you immediately, right? You will have to go through a few processes, and after that, you'll be able to get the car. So at that point of time, the possession is still with the seller. The car is still with the seller, but you are now the owner of the car. So the ownership is with the buyer. So the Act, it uses the term general property, which implies that sale involves total ownership and not a specific right limited by conditions. Total ownership in a sense, the entire property, the good and the bad, everything belongs to the buyer of the goods, okay, and not just a name, but full property should be given to him in his hands. Now, delivery of goods, it basically refers to a voluntary transfer of possession of goods from one person to another, and it may be constructive or actual depending upon the circumstances of each case. That is, you may actually deliver the goods, or you may deliver just the title of the goods, the deed, the papers relating to the goods. And a contract may provide for the immediate delivery of the goods or immediate payment of the price, or both. Okay, depending upon a contract, you'll either receive the property as soon as you buy it, and you have to pay for the goods also immediately as you purchase the goods. Okay, it depends upon the contract. Alternatively, the delivery or payment may be in installments basis, or it could be even postponed depending upon when the buyer and seller will agree upon as per the contract. All right, and then the fourth essential characteristic of sale of goods is consideration is price. So price, as we know, consideration, remember, is a very important element of the Indian Contract Act. And consideration also is termed as the price with regards to sale of goods. And price is an essential agreement for all transactions of sale, and in the absence of the price or the consideration, the transfer will not be regarded as a sale. Rather, it will just be considered as, gifting. Okay, so the consideration in a contract of sale has to be the price. That is, it has to be money. That's why we're saying money cannot be a subject matter for goods, even though it is a tangible and movable property. Now, if the goods are offered as consideration for goods, it will not amount to sale, right? In case you are giving, let's say you're offering sugar in order to get salt, it will not be termed as a sale, rather it will be a barter, right? You know about the barter system in the olden days where people used to exchange goods for other goods. Okay, so if you're doing that, it'll only be termed as a barter system because no money was involved. It cannot be termed as a sale. Okay, so if there is no consideration, then it'll be termed as a gift. If you're giving something to a person without payment, then it'll be termed as a gift. Now, the price can be paid fully in cash, or it can be partly paid and partly promised to be paid in the future, or it can be paid later in the future as a whole. Now, the price can be fixed by the agreement between the parties before the conveyance of the property, that is, before the transfer of the property. You can fix the price for the goods. But where the goods are sold for a definite sum and the price is partly paid in kind and partly in cash, then in that situation, the transaction will also be termed as a sale. Okay, in some situations, maybe you're giving something in kind, that is, you're giving some property. There is barter, at the same time, there is a sale. Okay, so in that situation, that is also going to be termed as a sale. So according to Section 2, subsection 10, price means the money consideration for the sale of goods. Now, if the price is not fixed, the contract is going to be void ab initio, which means void right from the beginning itself, from the start of the moment you enter into the contract. It will be termed as void if price has not been fixed. And the last essential characteristic of sale of goods is that it should it should have all the essential elements of a valid contract. So all the essential elements, in a sense, competent parties, then free consent, legal object, and so on. So transfer of possession and ownership under the Act has to be voluntary, and it should not be tainted with fraud or duress, which means there should be free consent. Okay, so it should consider also all of the various elements with regards to the Indian Contract Act. Why? Because it was a part of the Indian Contract Act itself. As a result of that, it still takes into consideration certain aspects or various elements of the Indian Contract Act, and it adds various other additions in order to make it different or to make it separate from the Indian Contract Act itself. Okay, so moving on, we're going to be talking now about sale and the agreement to sell. Okay, so as per the Sale of Goods Act 1930, basically you know that it deals with the sale of goods by now. Okay, so contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property and goods to the buyer for a price. So contract of sale is basically a generic term, and it includes both an actual sale as well as an agreement to sell. Now, Section 4 states that if the property in the goods is transferred to the seller, from the seller to the buyer under the contract, then the contract is a sale. Okay, wherein Section 4 states that if the property in the goods is transferred from the seller to the buyer as per the contract is termed as a sale. Where the transfer of the property into goods will take place at a future time or is subject to certain conditions to be fulfilled, then the contract is said to be an agreement to sell. Okay, we will sell only if this happens, we will sell only at a future date, then it's an agreement to sell. So such an agreement to sell becomes a sale only when the period time elapses or when the conditions are fulfilled, only when they have finally transferred the ownership, the property. Only then will an agreement to sell become a fully fledged sale. Okay, in other words, under a contract of sale, when the property and goods is transferred from the seller to the buyer, contract is sale, but where the transfer of property of the goods is going to be taking place at some time in the future or subject to certain conditions, then the contract will be termed as an agreement to sell. This is as per Section 4, subsection 3. Now, an agreement to sell becomes a sale when time elapses or the conditions subject to which the property and the goods is transferred are fulfilled. This is as per Section 4, subsection 4. Okay, so let's look clearly into the distinctions between these two. So let's look at these distinctions for sale and agreement to sell. So the first point you can see there, sale is an executed contract, whereas an agreement to sell is an executory contract. Okay, sale is something that is already done. Agreement to sell is something that is yet to be done. Okay, executory, or it is in the process of being done. Executory contract. And the second point, in case of sale, the property will pass immediately. The property and the goods sold will pass to the buyer at the time of the contract itself. Whereas in case of agreement to sell, the property takes place, transfer of property takes place at a future time. The property will pass, the property passes only when it becomes sale on either on the expiry of the time, okay, when the time limit has reached, or through the fulfillment of certain conditions. So therefore, it takes place at a future time or subject to fulfillment of certain conditions. Okay, sale will take place at future time or on the basis of certain conditions. And in addition to that, in case of sale, the transfer of risk takes place immediately. Not just the right, but also the risk also. It is related to the ownership. So, and when ownership is transferred, the risk also passes to the person. Like, for example, when you're selling a car. So, you're selling also the risk of car accidents. Okay, you're not just providing the property, you're also providing all the risks involved with the property. So, if there is a loss of goods, it will fall on the buyer, even though the goods may be in the possession of the seller himself. All right. And in case of agreement to sell, there is no transfer of risk or loss of goods because the ownership has not yet been transferred. So the loss will have to be borne by the seller, even though the goods may be in the possession of the buyer already. Okay. Whereas in case of sale, remember, the risk will transfer immediately the moment you get the ownership. And next, the seller can sue the buyer for the price of goods. Now, since the property has passed on already to the buyer, so in case there is a breach in the contract due to the buyer, then the seller can sue the buyer for price of goods. However, in case of agreement to sell, the seller can only sue for damages. In case there is a breach of contract, the seller has the right to only sue for damages unless, of course, the price was payable at a particular date. Okay, unless he has not yet paid anything, then he cannot sue if he has not paid for anything yet. And with regards to the rights of the buyer in case of a breach, in case of sale, then he can sue the seller for damages. Okay, just like in case of a breach due to the buyer, then the seller can sue. So in case of breach due to the seller, the buyer can sue the seller for damages. He can also sue the third party who bought those goods for the goods. All right, if somebody else has purchased the goods that he meant to buy after they have entered already into a contract, then he can sue the seller. He can also sue the third party who bought those goods. All right. And when it comes to the agreement to sell, the buyer has the right to only sue the seller only for the damages. In case he's paid for something, he has some losses, then he can only sue for the damages only. So next point, the seller has to deliver the goods to the official assignee except where he has a lien over the property. This is in case of insolvency of a buyer before he has paid the price. All right. However, in case of agreement to sell, the seller can refuse to deliver the goods to the official assignee or receiver in case of insolvency of buyer before paying for the price of the goods. All right. So this is the difference between sale and agreement to sell. So moving on, you also have to know about the differences between sale and hire purchase agreement. So a sale, as we already know, is when there is buying and purchasing, okay, buying and exchange of money. So when it comes to hire purchase, it is also quite similar to sale. However, in case of hire purchase, it is basically an agreement to hire the goods and pay for them in the form of installments, okay, rental installments. And later, once the last installment has been paid, the person, the hirer of the goods, can decide whether or not to buy the goods. Okay, so let's look at the distinction between these two. Firstly, the contract of sale. Contract of sale is governed by the Sale of Goods Act 1930, whereas under for a hire purchase agreement, they are governed by the Hire Purchase Act of 1972. Secondly, when it comes to contract of sale, remember, it can be written, oral, it can even be implied. However, in case of the hire purchase agreement, it should always be in writing. Okay, in case of contract of sale, it can be in writing, can be oral, it can even be just implied through actions. However, in case of hire purchase agreement, it should always be in writing. Remember that. And then when it comes to possession of goods, in case of contract of sale, possession may or may not transfer immediately. However, in case of hire purchase agreement, possession will pass immediately to the hirer or the buyer of the various goods. Okay, and then when it comes to transfer of ownership, the ownership of the goods will be immediately transferred in case of contract of sale. Remember, when we're talking about contract of sale, we're mostly talking about the sales that has already done. Okay, not agreement to sell, but about sales. But when it comes to the hire purchase agreement, the transfer of ownership will only be done when the option to purchase is exercised and the last payment has been made. So as we stated earlier, when it comes to hire purchase agreement, you are renting the assets and you will be paying rental agreements on them, and you are not getting possession of the goods. You're not getting ownership of the goods, but rather you're only getting possession of the goods. And if you want to purchase the asset, then after the last payment has been made, then you can purchase the asset. And after that only can you get the ownership of these assets. And when it comes to buyer, the buyer becomes the full owner of the goods in case of contract of sale, whereas in case of the hire purchase agreement, the hirer will be termed as the bailee and not the owner. He's just going to be the person who has the asset, and he will not be the owner until he pays all of the installments of the price in full, or he exercises the option to purchase the particular asset. And when it comes to the contract of sale, the right to repossess, the seller has the right to sue for the price of goods, but he cannot repossess the goods. Okay, the seller can sue for price of goods, but he cannot repossess the goods. However, when it comes to hire purchase agreement, the hire vendor, that is the person who owns the asset, the seller, he has the right to repossess the goods if the hirer, the person who is using the asset, defaults in the payment. Okay, at the same time, in case of the contract of sale, there is no option to return the goods, so there is no right to terminate the agreement. Okay, in a sale, there is no option to the buyer to return the goods bought, so there is no way they can terminate the contract of sale after the transaction has already taken place. However, in case of hire purchase agreement, the hirer can terminate the agreement before the ownership is transferred. So before they are actually sold, he can terminate the entire contract. Okay, so this is about hire purchase and sales, and these are the distinctions that are clearly seen between hire purchase and sales. Okay, remember, in case of sales, it is an exchange of the goods and in return for certain amount in consideration, which is the price. However, hire purchase agreement is basically an agreement for hiring of goods, wherein the person who's hiring the goods has an option to purchase the goods at the end. Okay, they're paying in terms of installment, and once the installment has been paid off, he has the option to purchase the goods, and the possession of the goods will be delivered only if he has paid once he has entered into the agreement, but he is only getting possession, and the ownership will be given to the person only if he has agreed to purchase the particular asset later in the future. Okay.